Welcome back to the second part of our workshop. Sorry, we're starting a little late. We've had the usual technical issues. And it turns out that on Zoom, computers are like cats. You can't have too many in the same room without them kind of hissing at each other. So we apologize about that, but I think it's all good now. We're going to pick up where we left off with the presentations this morning that focused very specifically on a few of the more interesting recent developments, with a heavy emphasis on remedy and a heavy emphasis on the judicial process and judicial interventions, as well as the developments with a particular focus on Germany in the mandatory supply chain laws. We're going to now broaden our perspectives, both with respect to and again, no hidden agendas here, to my great delight, broadening the perspective from a kind of human-centered, rights-based human rights approach to where I think we ought to be, which is a much broader, centered on sustainability, environment, and especially climate, as well as what countries outside of the European core are doing, with a particular view into the U.S. And then we will end the session with my co-convener Claire, who will present I'm going to be bad, the goings on in the EU, and then finish the workshop. And I think with that, I am a little early, but I'd rather give Sarah more time than to hear myself babble needlessly anymore. Sara, if you can take the floor, please introduce yourself, and then you're on.
Great, thanks Larry, and thanks Claire for including me in this work and also in this symposium. I'm going to share my screen, which hopefully is working well. So let me adjust something here. Perfect. Okay. So I was asked to draft something, as Larry noted, that focuses in on the environmental, sustainability, and climate lessons for human rights due diligence. We played around a little bit with titles, and I think this is where we are, although we can decide whether that's the best one after this presentation, perhaps. I've entitled it Lessons for Human Rights Due Diligence from International Environmental Law. I am at Dalhousie University in Nova Scotia. I'm with the Marine Environmental Law Institute and the Schulich School of Law, and I'm also the Yoga Sankheti Chair in Human Rights Law here. So here's where we sort of landed after I received some excellent comments on what I would call my sort of all over the place papers. I tried to grapple with how best to approach the project. The questions I think that I'm going to address in the first part, and then some reflections in the second part, are on this slide. Where does due diligence come from in international environmental law? What is due diligence in international environmental law, and how can or should due diligence in international environmental law and international environmental law more broadly influence due diligence in business and human rights? But I note, if you look at my little image here, that the question of how to understand what international environmental law even is not necessarily so straightforward. It has a close relationship with international sustainable development law. One might think of international climate law and parts of the international law of the sea as part of international environmental law, but again, they're not exactly the same thing. And then how do we think of human rights in relation to all of these areas is not a separate topic. So we will, as I note on the slide, also have a bit of a reflection on what is international environmental law and what that might mean from where we draw lessons. If I am thinking of international environmental law as a good starting point, and I do think it is, I would often turn to the work of the UN Environment Program, and I note that they often frame things these days as being the world being in a triple planetary crisis. So yes, climate change is crucially important, but it's interrelated with nature loss, biodiversity loss, also a huge crisis, and pollution and waste. And so we often have a situation where solutions to the climate problem may have a negative impact on nature or on pollution. That isn't really helping us to address the triple planetary crisis. So it's really important to think of these as interdependent and all as having implications for human rights. Now, if we start with where does due diligence come from in international environmental law as a good starting point, this forces us to think about what the sources are of public international law. Unfortunately, there is a problem with the way in which international environmental lawyers typically draw their sources. There's a lot of critical scholarship on the problematic nature of the civilizing mission of international law. And this is something that's very much central to my thinking as a Canadian lawyer based at Dalhousie, where I am on the ancestral and unceded territory of the Mi'kmaq people, where we are all treaty people. Now, of course, the first source of public international law is treaties, but that's generally not thought to include the peace and friendship treaties, which are the ones that govern the land where I am based. So that's a problem. And it's also a problem because if we're really serious about addressing environmental problems, a really good source in the Canadian context is often what one might refer to as Indigenous ecological laws coming from different Indigenous nations and traditions, including here in Mi'kmaq. So can or should those be understood as sources of public international law to inform what we understand to be due diligence in international environmental law? Yes, they should, but that's not how I wrote this paper and probably not what the editors were thinking. So we can have a conversation about whether, and if so, how that should be part of this project. More traditionally, it's common then to look at judicial decisions of, for example, the International Court of Justice, the International Tribunal on the Law of the Sea, to see where due diligence comes from in international environmental law. We could also perhaps look at domestic decisions. So somebody's made reference earlier to the Royal Dutch Shell case, which has a lot of interesting things to say about business and human rights and its relationship with climate law and the responsibilities of Shell. I didn't refer to that in the paper, but again, could have. What I did refer to, and certainly have delved into in quite detail in earlier work, is the work of the International Law Commission in codifying draft articles on the prevention of transboundary harm, often focused on environmental harm, and the loss allocation principles. I also looked at the work of the International Law Association's study group on due diligence, which looks at due diligence in a wide range of areas of law, including international environmental law. Those primary, aside from the RDS decision, the first sort of three areas of sources that I've noted here are thinking largely about due diligence in a particular spatial context. So what I would call transboundary and global harm context, which I'll talk a bit more about on the next slide. But if we are looking really to the foundational principles at the heart of international environmental law, we would turn to the real principles on environment and development. How to think about them as a source of international environmental law? Well, they're often, many of these principles are found in treaties. Some of these principles are said to reflect customary international law or to be general principles. They're certainly referred to in judicial decisions and so on, but each principle has been, or the real principles as a whole, are re-endorsed by the international community on a regular basis. And so I think are a really important piece of helping us understand not just the transboundary and global aspects of international environmental law, but other spatial dimensions that I'll note on the next slide. And the final, if we're thinking about sources, the final piece that's a bit tricky is to think, can we and should we think about international environmental law as entirely separate from international human rights law? It's very definitely the case that the UN Environment Program has been working closely with the OHCHR on how to think about human rights and environment issues. We have special rapporteurs. We have much action that's been happening at the intersection of human rights and the environment. And I note, for the purpose of understanding due diligence in international environmental law, as thought to include this human rights and environment work, the framework principles from 2018 that were developed by John Knox, the special rapporteur, I think are particularly useful. This slide provides some detailed sketches on how to answer this question: what is due diligence in international environmental law? And I note much of this is aimed at states, but there's some that sort of provides guidance on how states should, well, how states should regulate non-state actors. But there's also the question of how some of it may or should be thought of being directly applicable or relevant to non-state actors themselves. In terms of scope, I already noted that many sources focus on transboundary or global harm. Sometimes common concern is another phrase that we hear in terms of climate, for example. But one could also alternately think of transnational harm as being a different spatial dimension. So if we could put human rights due diligence laws in that frame. Initially, when I've done work in this area, I've thought of it more in terms of a mining project, for example, being located in one country, but the home state playing a role in governing what happens in the host state. There's also, hugely importantly, the need to think about what state obligations are intraterritorially. So we heard some reference, for example, in the German context to what it means for the due diligence law to apply within Germany. And that should be part of all of these human rights due diligence laws. They shouldn't just be for outside the country. They should apply outside and inside. But international environmental law may have different things to say about state obligations in the intraterritorial context. I also note a lot of work on regional assessments, ecosystem assessments, and I'm leaving that to the side. Now, if we think about again, the sort of dominant international environmental law due diligence lessons for transboundary and global concerns, the starting point would generally be Principle 2 of the Rio Declaration, which talks about the sovereign rights of states to exploit their resources in accordance with their own environmental and developmental policies, but at the same time, the responsibility to ensure that what they're doing does no harm to the territory of other states or areas beyond the jurisdiction of any state. So that's our transboundary and global commons kind of obligations. No, and I have suggested that by analogy, I think we should think of the transnational responsibilities as also being something that could fit within the transboundary and global commons understandings. Certainly in the work of the ILC and others, the language that's used is often the obligations of a state of origin, and there's often reference to the location of the owner or operator. And you can see this as being quite potentially applicable to, headquarters of transnational corporate actors. But the Rio Principles, international environmental law, also has things to say about intraterritorial harm. So for example, Rio Principle 8 says that states have responsibilities to have effective environmental legislation. But first, there's a question of what does that mean? Environmental legislation is never structured as not do no environmental harm, or at least I won't say never, but that's not the dominant approach. And embedded in the Rio Principles is the idea that the standards used in environmental law may be different in developing countries from in developed countries. This puts us on a collision course because from a human rights perspective, informed by a right to a clean, healthy, and sustainable environment, indigenous rights, and so on, it may be that A state may be quite happy with a certain level of environmental protection, but communities may wish or believe that they're entitled to higher standards, and particularly if transnational corporate conduct is involved. The rest of this slide talks about process, content, and consequences. There's a lot in international environmental law about the kinds of processes that can and should be undertaken as part of doing diligence, obligations of prevention, precaution. So in the case of scientific uncertainty, how does human rights apply? Certainly international environmental law, through the precautionary principle, has something to say about that. The importance of prior assessment of environmental impacts is in international environmental law, judicial decisions with regard to transboundary and global harms, but it's also something that states can and are doing globally with regard to intraterritorial harms. There then the intersecting procedural rights aspect. We see this in Rio Principle 10, to information, participation, and justice, expanded in the 2018 framework principles through the human rights and environment lens to include freedom of expression, association, environmental education, safe space for environmental defenders, free, prior, and informed consent for Indigenous communities, and so on. But the point is that in domestic environmental assessment laws, for example, all of these are quite foundational and fundamental, implemented in differing degrees in different states, in different contexts, and even within states. So I could compare, for example, how the Federal Impact Assessment Act in Canada is structured compared to the Nova Scotia environmental assessment legislation. But certainly these are not foreign things. These are aspects of environmental legislation, both in the intraterritorial context and in terms of the transboundary and global, though to different degrees. The other piece I note in terms of process is the idea of polluter pays. In theory, we might think that polluter pays is about making sure that those who've been harmed have remedy and that the environmental landscape is being remediated and so on. In practice, environmental laws encouraged by international environmental law often adopt different types of market mechanisms. And these can include the use of offsetting mechanisms, for example. So an easy example might be in the climate context. So, beware net zero. It's different from zero. Zero means you've reduced your emissions to zero. Net zero means you've reduced your emissions maybe, but alternately purchased offsets to offset your emissions. No guarantee that that actually works. Another common polluter pays type pricing mechanism is carbon pricing. No guarantee that carbon pricing is actually going to reduce the emissions. And more concerningly for consequences, for example, carbon pricing does not ensure that the price ends up going to restoration or liability or compensation. I'm conscious that I've already been speaking for 10 or 12 minutes, so I'm going to go a little more quickly through this part just to note under content. The first part are things I've drawn from the work of the ILC in terms of what one would have to do to meet a due diligence expectation. I've already mentioned the problematic aspect of offsetting, which we can see as part of mitigation, but there are other aspects too. Consequences in domestic law, often a due diligence defense is common, certainly in the Canadian context. The idea of stricter absolute liability is less common. Internationally, there is a challenge always of negotiating liability and compensation regimes, or even if they're negotiated, having enough states become parties for them to enter into force. So this has always been an outstanding issue. And then I note, really at this stage, restoration of the environment is what's needed. Liability and compensation that doesn't actually restore natural systems isn't going to get us where we need to go. So how can or should due diligence in international law or international environmental law more broadly influence due diligence in business and human rights? I've already noted a lot of stuff about the due diligence aspect, so I'm going to just focus on a few principles more broadly we might want to reflect on. First of all, the idea of common but differentiated responsibilities and respective capabilities is again a foundational and fundamental principle of international environmental law. Rich countries have contributed the most to environmental degradation. Poorer countries have face greater challenges. Often, if you look at per capita consumption rates, etc., it continues to be the pattern that, aside from the wealthy in poorer countries, it is the dominant footprints of richer countries continue to be more ecologically destructive, and the ability to actually address environmental harms through law remains challenging in many developing countries. There's a lot to be said in that, but I'll leave it at that. Point being, not sure how that plays into the human rights due diligence laws, except perhaps this assumption that if the richer countries have these human rights due diligence laws, this will be helpful to the poorer countries. We need to make sure that's actually the case. Cooperation is also fundamental in international environmental law, and that has included things like technology transfer and all kinds of other compliance mechanisms to help poorer countries meet obligations under international environmental law. And there are also principles of intra and intergenerational equity. Intergenerational equity could be met in part through rights of the child thinking. And then finally, for the moment, there's the question of sustainable development. I'm going to come back to sustainable development. Oh no, I'm not. I'm going to talk about it right now. Here's one of the challenges. If we just take an international environmental law lens, the question is, how do we define that and understand its relationship to what might be seen as a broader body of law known as international sustainable development law? I note in the picture a book that I co-edited on environmental justice and sustainable development, where we focus in on the social pillar. But I think it's important to see sustainable development law as bringing environment, human rights, and economic law together, not as a stool where each is balanced, but drawing on in a version of the donut economics sort of thinking, to understand that the environment is a floor and a ceiling. You must have, in order to have healthy societies, you must have a healthy and resilient environmental floor. But equally, economies cannot and should not exceed the reality of planetary boundaries in an environmental context. So I prefer a sustainable development framing as something that can encompass the human rights due diligence laws, rather than seeing human rights as its sort of own separate special thing. That said, there are problems with the sustainable development goals. They don't fully address the need for rich countries and consumers to really reduce consumption patterns. And we can talk more about that. We're not. Again, the problem, as I see it, is unsustainable production consumption patterns contribute to interdependent crises with impacts on human rights. And perhaps human rights due diligence across supply chains is part of the solution, but I think only if it includes the right to a clean, healthy, and sustainable environment. And this is my last slide, I think, which is an image that I developed in work for the UN Environment Program, conceptualizing holistically the component parts of a right to a clean, healthy, and sustainable environment, drawing on the framework principles and other work. And so I think the question is, if we're thinking of lessons for human rights due diligence, this is from the framework principles, I lied. There we go, one more. If we're thinking of human rights due diligence in relation to international environmental law, the question is, how do we understand international environmental law? Does it include the human rights and environment instruments, including the right to a clean, healthy, and sustainable environment? And if so, what lessons emerge from those? Or are we thinking about a more traditional approach to international environmental law and the transboundary relationships and global relationships that emerge? Thank you.
Well, thank you very, very much. And that was an extraordinarily, as usual, an extraordinarily rich banquet that's going to take me a while to digest. But I will feel not only full, but satisfied. So I want to throw it open. Questions? Questions? I can get the ball rolling by throwing a proverbial stink bomb into the as is my
Yippee.
nature. As is my nature. You danced around this, and I saw it in there, but I'm going to play just a little bit. Sitting at the peripheries of all of this, and sometimes with a greater effect, for example, in Marxist-Leninist states, and sometimes in post-colonial states, and sometimes not, is the nature and edifice of development. Something that has been a principal issue coming out of the post-colonial movements in the 60s and 70s, developing into its own structures, both within and outside of human rights by the 1980s, and sitting here as a kind of sometimes a weight on the ability to fully develop the necessary sensibilities, not just for environmental, but for sustainability as well. How would you, or how can you, or is there a way of embedding these sometimes contradictory and sometimes incompatible forces, or maybe they aren't, within the process of due diligence that gets us to that mix of prevention, mitigation, and remedy that a society, either international society or contextual societies, want in ways that don't make people crazy?
Great question, Larry, as to be anticipated. So I think increasingly, the problem is that people focus on development and don't focus on overproduction and overconsumption. So I've made this point about the Sustainable Development Goals. You wanted me to say that.
I did. Yeah,
it's in there. The problem with the Sustainable Development Goals is they pay lots of attention to the need to lift people out of poverty, but they don't say anything about the need for those who are consuming more than their fair share of global resources to cut back, to stop. And I think the best we're getting in some countries are things like right to repair legislation, like that corporate actors are actually creating products in a way that make it impossible or difficult for people to repair them, is fundamentally a human rights issue from an environmental perspective, because the reason we're having all these problems in terms of environmental crises is because there's too much consumption going on, and that needs to somehow be addressed. Now, how do we do that through human rights due diligence? It's tricky, but you see often in parallel laws that talk about consumption patterns. But I think there needs to be more careful thinking about that, and not, the pushback on the development is, yes, right to development to a certain level. There's, happiness index. There's also degrowth literature and so on and so on. Anyway, I'll stop.
All right. Other questions from folks? Carolyn.
A very simple question, or short question. On your first slide, you mentioned marine environmental law. So what do you mean is the added value? What can we learn from marine environmental law?
So the reason there are two reasons why I would note marine environmental law. One is because I'm director of the Marine and Environmental Law Institute, so I kind of have to mention marine environmental law. But also because if we're looking even just at basic sources, if we're looking at very traditional sources of international law, the law of the sea is a long-standing source that has a lot to say about pollution of the marine environment. And we do have an international tribunal on the law of the sea that's come out with some very interesting jurisprudence and very useful jurisprudence for understanding due diligence. And also right now, for example, there is the climate advisory opinion that is being heard again by the International Tribunal on the Law of the Sea. So often, it's like definitionally it's challenging, right? Like there's even if you look at the SDGs, they say there's life above water and life below water, except they're all interconnected. Climate is related to oceans and so on and so on. So yeah, absolutely, just as much a body of law as terrestrial environmental.
Mhm.
Other questions? Well, I'm sorry, I can't resist, and hopefully someone else will have a question as well. Good, Anil, thank you.
Hello, hi, thank you, Sara, thank you, Larry. My question is about whether human rights due diligence in the context of business and human rights can learn from the concepts that you discussed, not necessarily due diligence, but things like prevention, things like FPIC, or other concepts that have been already used for a longer period of time, I guess, in the context of international environmental law, successfully and unsuccessfully, I guess. Is there any room for learning for the business and human rights context for these emerging new frameworks and laws from environmental law? Thank you.
Thank you for that question. And I think absolutely, it's interesting as somebody who's been teaching environmental law for quite a while. Of course, there's always a chapter on environmental assessment in the book that I use, just in the domestic context. And environmental assessment is an incredibly well-developed field of law. The Canadian dimension that's very interesting is our new federal statute is not called an Environmental Assessment Act. It's called the Impact Assessment Act, and it incorporates aspects that are human rights and social dimensions without speaking specifically to human rights. So I think there are all kinds of different tools in the environmental context, and environmental assessment law and impact assessment law more generally is a really rich body of law to look at for ideas. And it includes, again, because if you think of the Rio Declaration of Principle 10, the idea that people have rights to access information and to participate in decisions and to have access to justice and seek judicial review of decisions by government decision makers and so on is very fundamental. This is not new, but I don't think it's stuff that human rights, people in the human rights field are terribly familiar with often, unless they happen to be, teaching environmental law.
Excellent. I'm sorry, I'm going to do this to you. Risk. One of the things that's very interesting, I think, in looking at the development of due diligence in the human rights context, as opposed to, and you did a marvelous job of bringing this out in the environmental and now the sustainability due diligence context, is the way in which risk and risk assessment is itself used to privilege either prevention, mitigation, or remedy. And we'd already discussed earlier how, depending on which of those you focus on, you will have very different results. And there's a natural tendency within private law to privilege remedy, and within public and administrative law to privilege prevention. And then the sweet spot is, of course, mitigation, but you sacrifice. And so what I hear you suggest is that in environmental and sustainability law, the way in which you look at risk, or you embed risk within your risk analysis, tends to focus on mitigation with then an eye towards prevention if you can, and remedy if you must. Human rights due diligence, when it's focused, when it comes out of the state in a mandatory human rights context, tends to focus on prevention. When it sits within private law frameworks, tends to focus remedy. And within some other states, there's a stream of Marxist-Leninist approaches, which is development-based, that also focuses on remedy. Does this variegation suggest that we ought to be flexible, or we ought to embrace this flexibility, or does due diligence now make unavoidable that discussion that we seem to be avoiding about whether or to what extent we ought to regularize the way in which we create hierarchies of prevention, mitigation, and remedy through the context of, and then augmented through due diligence mechanisms.
That's a really interesting question. And I'm going to go back to the previous one for 1 second, just to note, and I think this will link into this as well, that one of the very interesting developments in the federal impact assessment law in Canada is that it provides space for Indigenous-led assessments. And that, right, is right away opens up a different aspect. If you're recognizing Indigenous jurisdiction for projects that are going to impact Indigenous lands, and they're right involved, head up in the assessment process, then to the extent that that's also linked to the same communities, perhaps either are the project proponents themselves, because of course Indigenous communities can lead development projects, can lead oil and gas extraction just as much as other things if they choose to, and it's allowed in their state and so on. But you have there the possibility of impact benefit and sort of holistic frames. The interesting thing is impact assessment laws, environmental assessment laws, have always been understood as planning tools. But the planning then, the problem is when a proponent comes forward with a project, they've sunk enough money into it to have the basic information in order to go through the assessment project. But because there's a chance in many jurisdictions that they won't be allowed to develop it, they certainly haven't sunk in a ton more money to know exactly what the environmental impacts might be and exactly what would be needed to actually address them. So often you have embedded into the outcome of an environmental assessment process ways to sort of manage risks moving forward, which could include weird things like adaptive management. And this is very contested. How do you understand that? How do you rule? How do you govern it? How do you address it? So I think unless, in a sense, the rights holders are upfront in the process of determining what and how a project goes ahead and at what standards, we miss a lot. But the usual way is not to do that, and I'm not quite sure how human rights due diligence approaches sort of the human rights due diligence through the supply chain can sort of address that. And that's, I'm sort of going off, but I think it's, there's this body of law, like starting from the prevention impact assessment of a project process, but that also exists within bodies of regulatory laws that say, when you're, even assuming your project is approved, you still have to comply with, this and this and this and this. And for those, if you don't comply with those, maybe there's a remedy piece. So it's complicated. It's not a simple, multifaceted.
Claire, you have the last question for this session.
Yes. Hi, Sarah. Hi. So, yeah, thinking about the EU corporate sustainability draft due diligence directive, but this can apply to other, imagined or foreseen schemes as well for statutory due diligence obligations. So environment has been added to human rights in terms of the scope of the required due diligence exercise. And we've seen that in the French law, the German, and also in the Business Human Rights Treaty draft in the UN. So I'm just wondering from, where you stand as an environmental lawyer, what guidance do you think is available from an IEL point of view, maybe from a national environmental law point of view, but the guidance that will be available to, the courts that have to evaluate ultimately the adequacy of the due diligence undertaken by business entities, considering that they will be required under most of this legislation to assess whether there's been an adverse impact on the environment. In some cases, they'll of course also be required to assess how such an environmental impact may have impeded the enjoyment of human rights. But where are we in terms of national or international standards that will help to guide these evaluations of whether there has indeed been what can be determined legally to be an adverse impact, given that different countries have different standards, or it's a patchwork with lots of holes in it probably as well. So leaving to one side, I think we heard from Birgit Spieshofer this morning sort of that there was some controversy over ultimately whether the due diligence obligations in the German statute at least can really be considered as imposing a duty of best efforts or reasonable efforts, or actually in effect whether they impose a duty to secure a particular outcome. But yeah, leaving that to one side, how does this look? Is it a meaningful exercise given the present state of standards that are available to put companies and courts in a position of having to make these determinations about what's an adverse impact?
Right. So I think, I'll say I haven't looked within recently at the EU draft, so I don't know where it is right now. When I had last looked at it, I was scratching my head a lot as an environmental lawyer to try to understand how the environment sort of fits in. I think I would make these comments. First of all, to the extent that businesses have to comply with environmental assessment laws in many jurisdictions, and also environmental assessment requirements as part of a risk assessment for financing and so on, it probably won't be that difficult for most to sort of show that they have been undertaking something that one could describe as a due diligence. And so then it's a question of, has what they've done sort of met the standard? The important thing, which is tricky, is to grapple with this idea of significant impacts. So for example, in the Canadian context, our environmental assessment legislation used to be one that was focused on identifying significant adverse biophysical effects, so in pure environment effects. There's a push to move towards to say that that's really the wrong test. Maybe we should be asking, does this project make a positive contribution to sustainability, for example? Quite a different question. Alternately, looking at carbon emissions, how do we quantify those? How do we do these things? So I think first off, the idea of adverse impact in the environmental context is complex. Is the first note. It's not a simple, straightforward one. And so I guess I think what I'll try to do in the paper is try to draw out what could be the lessons for these human rights due diligence legislative approaches. But I would do that with the caveat that it would be really helpful if the people thinking about human rights due diligence started to think about how that work actually intersects with and informs and could be part of what exists in the international environmental and domestic environmental law lens, which is what I'm doing in my environmental law course and text, telling them about business and human rights. Because I think that needs to be done. The human rights people need to get into the environmental world and meaningfully take it seriously and look at what's already there and how these issues can be addressed within that, rather than reinventing the wheel outside and trying to add environment in and stir, because it doesn't work that way. The only way you could do that maybe is to take human rights and environment out and just accept the right to a clean, healthy, and sustainable environment as a human right. So we're not talking about human rights and then environment. We're saying human rights due diligence includes the right to a clean, healthy, and sustainable environment. That's really important for getting over the fact that we have routinely, for example, industrial facilities that are all sited together in poor neighborhoods that are often racialized and marginalized. That can be done in accordance with certain environmental standards that are completely out of keeping with a right to a clean, healthy, and sustainable environment. So I think there are different ways of sort of going about this, and I'll do my best in the chapter to pull out something useful. Thanks.
Well, thank you very, very much for a brilliant presentation and conversation. Unfortunately, we need to move on, and I will turn the floor over to Eric.
Great. I hope you can hear me okay. Thank you,
can.
Larry and Claire. I'm really pleased to join this distinguished group. It's been very impressive. I got on this morning at around 6:15 my time, so about 11:15 there, and I've been able to listen in, and it's informative, illuminating, maybe a tad intimidating, but extremely useful, including to consider how our little chapter may fit in. A couple of quick things about us, meaning myself and my co-author, Carlos Vázquez. Carlos is a longtime senior faculty member at Georgetown University Law Center here in Washington, I think going back about 3 decades. He and I, as young lawyers back in the 80s, actually got to know each other and worked on some cases together, including filing a couple of amicus briefs in some of the early litigation to test the use of the Alien Tort Claims Act, Alien Tort Statute. So we've known each other a long time, although our paths have diverged a little bit as he became respected full-time academic, now associate dean, which is keeping him from joining us today as the students return to campus at Georgetown this week. I am, by comparison on the teaching front, lowly adjunct, but which I've done for 15 years at Georgetown with my colleague Meg Rogensack, and also recently for a portion of our course, Sara Altschuler, who works at Verizon and brings a telecom and tech background. So we've taught a business and human rights seminar for 15 years. It's evolved quite a bit, as you can imagine, as the field has developed, but we continue to enjoy teaching it each spring as part of the broader human rights curriculum at Georgetown. The rest of my time beyond teaching, I'm currently a senior advisor at the Fair Labor Association, which is a multi-stakeholder initiative that's been around since the late 1990s, mainly apparel and footwear, also agriculture and some other entities on the business side, plus universities, plus civil society organizations working, as I say, primarily to address working conditions in the apparel and footwear sector, but also increasingly in agriculture. So you can kind of get a sense of what issues might arise in that context and where that brings experience in trying to address some human rights due diligence. It seems like on a daily basis. For one of my responsibilities has been running our entire grievance mechanism procedure and trying to make some use. I think we're fairly advanced as multi-stakeholder initiatives go, but we still have a long way ahead in terms of non-judicial, non-state-based mechanisms for making good on the framework of the third pillar of the UN Guiding Principles, among other tools that frame our work. I am not going to use slides. I started into working on slides, and then I thought I was really figuring I might well jump around a fair amount in my presentation, and the slides might end up being more confusing than helpful. So after some of the terrific slide presentations earlier, I'm thinking, was that a mistake? But you won't see any slides from me. This will be really a flow of talking about some of the overlying issues and then getting into the content of the draft paper, which has benefited from one round already of excellent feedback from Larry and Claire. So that's a little bit about the framing, the background. I will say that there's a little bit of genius, if that's the right word, in the title that we were provided, and I have not changed, Carlos and I have not changed it, for our chapter, U.S. Measures to Give Legal Effect to Human Rights Due Diligence. This lends itself to a bit of a different focus in our writing, in our analysis, than some of what I've heard over the last few hours, which was outstanding in terms of providing interesting methodological frameworks. I'm not sure that we achieve anything of that sort. This is pretty much a cataloging of what's been done to date in the United States, an analysis of both the achievements and the gaps, with a bit of a heavy emphasis on the gaps in the U.S. approach to human rights due diligence. One thing we do in that context, and I know Claire and Larry had some thoughts about this, is we do begin by focusing on the EU briefly. Obviously, there are other papers that do a deep dive and analysis of what's been happening in the EU and in some of the key member states, including Germany and France and so forth. The reason we do that is not necessarily to treat the EU as a benchmark for the US, but the truth is there has been some scholarship, and there certainly has been a lot of discourse, including among colleagues on the Business and Human Rights Forum, BHR Forum site, who, and also in comments submitted to the US government in connection with the National Action Plan on Responsible Business Conduct process, which I'll come back to in the last 5 minutes of my remarks. For those unfamiliar with the National Action Plan, or the NAP for short, at least the US version of it, it really is a linchpin of what we're looking at from our perspective and what the US might do to address some of the at least perceived shortcomings in how the US has approached human rights due diligence to date. And again, I'll get into that in just a moment. But the truth is, there really has been a pretty common perspective, including in some scholarship and in this commentary that I just referenced, that the US has somehow fallen behind. In a couple of instances, folks have even talked about the US going so far as to say the US has abandoned its leadership position on human rights more broadly. I think that's a severe overreaction, but it's understandable if you take a centralized approach, a top-down approach, an organized, dare I say, approach. And in all of that, one does look to the EU, to the process leading up to CSDDD, CSDDD, and so forth. And one can't help but think about that and then look back at the US and say, how different this is. And does that reflect something severely lacking in terms of attention given to advancing human rights due diligence? And if so, why? Is it a lack of government capacity? Is it a structural barrier based on the organization of the US government? The three branches, the executive branch has some degree of ability to pursue initiatives. Congress jumps in kind of more ad hoc, and the judicial branch has, gone from staking out a lot of new ground in terms of mandatory due diligence of its own sort, when there was a lot of advancement in 2 decades or so of implementing the Alien Tort Statute, as well as other laws, the Torture Victim Protection Act, Trafficking Victim Act as well, but primarily the Alien Tort Statute. But all of that has come to a grinding halt with the guidance from the Supreme Court in a series of cases over the last decade and a half that has really largely closed the courthouse door to a litigation-based approach, and has left things in the hands of the other branches as the capacity to, while there continue to be some ability to tweak things and see if lawsuits can proceed, as my colleague Carlos knows better than I do from his scholarship, that's changed quite a bit. So the point of all this is we really evaluated the landscape of the United States government when it comes to human rights due diligence, and we come to, in at least our draft, acknowledge certain points in the critique, but a good part of the draft also pushes back on the idea that the US has somehow been sidelined. In fact, a great deal has been happening with, dare I say, some real impact. This has not been just talking about methods of imposing requirements on business, but even in the absence of an organized process, top-down process, there's been some real impact through measures in the US, and that's what I'll talk about for about the next 5 minutes. Even if it isn't under, an organized banner of human rights due diligence, at least not yet, taken together, we think it may qualify, based on a reasonable definition of what human rights due diligence is meant to advance, meant to promote. Very different than the EU, if it can be called an approach at all, given the lack of central coordination. Much more ad hoc from different parts of government, certainly not a whole of government approach, at least to date, although again, in the final few minutes, I'm going to talk about whether that may be coming slowly, but surely through the National Action Plan process. And focus mainly, though not exclusively, on forced labor, which itself both is an achievement and a potential critique, given that you haven't seen the same measures with regard to other labor standards, generally speaking, compared with forced labor and to an extent, child labor. So let me pause for a minute. What we try to do in the paper is first take a look at human rights due diligence and what it is, really meant to convey and meant to achieve, as we, begin by talking about, the alleged shortcomings and how to interpret what's really been going on. And, what we talk about is looking at the central objectives of human rights due diligence. In that regard, since there really is not a US-based document laying that out, we go back to take a look at, for instance, the European Commission's explanatory memorandum on the CSDD proposal, setting out the reasons for and objectives of the proposal. And after noting the accomplishments and talking about the fact that there need to be new steps in light of existing international standards on responsible business conduct being largely voluntary, what the EU Commission document talks about is the need to advance, quote unquote, legal certainty, and talking about due diligence through government regulation, and the different rationale for that, including supporting those companies themselves that have already committed to address their potential impacts, including in their supply chains, their value chains, and in doing so, establish a more level playing field than what a fragmented voluntary approach could achieve. So I won't take more than another 30 seconds or so to talk about, how we try at the beginning to lay out the purposes of human rights due diligence as a point of being able to measure how successful or unsuccessful the US has been in its efforts to date, in assessing the US experience broadly to date. We then look at the US due diligence landscape and look at 4 areas. I think it's 4, either 3 or 4. I think it's 4. I'll answer that clearly in the next couple minutes. Areas in which disparate US approaches exist for promoting greater corporate due diligence and strengthening corporate accountability. The first is, and arguably the most far-reaching to date, has been mandating due diligence through trade rules. Most of you are probably familiar with enforcement of Section 307 of the Tariff Act of 1930, as amended a few years ago in 2016, after years of neglect and non-use, which has really opened the door to, so that was a congressional action taken to modify an element of the Tariff Act that was holding back its use for several decades, and enabling it to be used to authorize the imposition of import restrictions on products made in whole or in part with forced labor. Once that an earlier broad exception that had undermined its effective application was eliminated by Congress, it opened the door to the executive branch and specifically to the Customs and Border Protection Office within the Department of Homeland Security to administer Section 307, which since around 2020, both this administration and its predecessor has enabled Section 307 to be utilized aggressively to deal with some well-documented examples of human rights abuses in Xinjiang, China, but also in other places ranging from Malaysia with palm oil to Dominican Republic with sugar. Congress couldn't resist stepping in, notwithstanding that Section 307 was already on the books and increasingly being utilized in a revitalized way starting in 2020. When Congress passed at the very end of 2021, the Uyghur Forced Labor Prevention Act, UFLPA, overwhelmingly with only a couple of dissenting votes, reflecting a rare broad consensus concerning the need to further strengthen the tools to combat imports from the Xinjiang region that were deemed to be made with forced labor. The relationship between Section 307 and the UFLPA is a bit complicated and really beyond the scope of what we're trying to do in this paper. But just to note that these trade tools, as well as some others that I won't get into right now, have been the primary mechanism used in the U.S. to enforce compliance and at least, if not in name, explicitly impose heightened due diligence requirements on companies, given the high bar that they apply. The reason I was waffling on whether there were 3 or 4 areas is the one area that I've already referenced that we haven't yet built out in the paper, and Carlos will be doing so, is the efforts to advance corporate due diligence through the courts. So I'm going to include that in our list, but with the significant caveat that the judicial opportunities to remedy due diligence shortcomings and promote accountability have been significantly circumscribed in the last decade or so, and that the time where those were probably viewed by many dedicated activists as the best way to get at these issues has certainly come and gone, short of a change by the Supreme Court and lower federal courts. So that's the second area in which, it'll be more of an accounting of what's happened than a recognition that there's a lot of opportunity to move forward there. Another area is use of procurement, leveraging the power of the purse, a typical way of talking about that, where there's been a lot of work done to essentially promote what the US government can do as a buyer and much more to build on prohibitions on forced and child labor and in other areas. I'll just note that one in passing. Finally, and maybe most interestingly in terms of a comparative analysis, you've got a range of steps in the US, baby steps in some areas toward enhanced reporting, disclosure, and transparency that have more in common with measures undertaken in other parts of the world, including in Europe. A lot of this in the US began at the subfederal level, particularly in California through the Transparency in Supply Chains Act of 2010, which has become a model for other actions at the subfederal level, both at the state level and even at the municipal level. Although I think it's fair to say the first decade plus of implementation of those initiatives has been marked as much by disappointment as achievement when you look at a number of independent analyses, independent assessments of how what the Transparency in Supply Chains Act and some other initiatives pivoting off of it have actually accomplished. a little more promising going back to the federal level of reporting, disclosure, and transparency have been some actions taken to advance due diligence objectives consistent with the criteria of the guiding principles by the Federal Independent Security and Exchange Commission, implementing provisions going back to the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, which lays the groundwork for some novel reporting and disclosure in areas that had long been a focus of advocates concerned about practices in the extractive sector. Section 1502 and Section 1504 specifically of that act. So there's been a whole body of effort in that area, even as there's also been a great deal of litigation by business to push back on use of those tools. There have been a couple of different rules promulgated, for example, on 1502, one that was invalidated by a court subsequently, and then another one that was finally adopted in 2020 with to kind of mixed reviews. So that's the place in the whole government where there's been, I would argue, the most activity somewhat comparable to that in other countries to build out the S of ESG, the social, and begin to at least move forward on seeing it as less of a laggard compared with the E and the G elements of environmental and governance. The SEC is also now considering proposals to require companies to report on their human rights risks and impact through their securities filings. And that's something we're going to build a little bit more into the next draft of the paper that holds a lot of promise. Finally, I think I'm getting close to being over time. I wanted to come back to what I mentioned a few minutes ago, the National Action Plan. This is the US's second bite at the apple in terms of a national action plan. When I was in government as a senior political official at the US Department of Labor from 2011 to the end of the Obama administration in January 2017, we had the first chance to advance a national action plan on responsible business conduct. And frankly, we didn't do a terrific job of it. Labor and portions of the State Department were promoting something that was beyond what other parts of the government were comfortable with at that time. And what came out just before the end of the Obama administration, in fact, after the election in 2016, was a national action plan that was more of a listing of measures taken to date than anything aspirational and forward-looking. Larry, time?
Yeah.
Okay, I will wrap up in the next minute. The hope is that any National Action Plan or NAP 2.0 is going to be a very different instrument and may well answer some of the questions we've all been pondering about, does the U.S. have the capacity to take a more coordinated approach to human rights due diligence? I will tell you, as part of an ongoing dialogue with some of the people in the U.S. government responsible for it, I am more optimistic at this point than I thought I would be, based on some conversations about, what they hope to produce by the end of the year. So we don't have a document in place. We could well find ourselves disappointed again. It's a work in progress, but based on the feedback that they've provided to comments received from a cross-section of CSOs and academics, including through the Business and Human Rights Forum, Rachel playing an important role in that, I'm cautiously optimistic that what we may see with the NAP 2.0 is the beginning of a more coordinated approach in the US that may overcome some of the skepticism about whether there's any hope for a greater US policy coherence on critical business and human rights issues that would amount to a different approach to implementation of human rights due diligence. Let me stop with that. I think I've already eaten up some of the Q&A time, and I would be grateful, and I know Carlos, who I'm speaking with on Friday, would be grateful for any comments, both in the limited time we have here and through just connecting with us on your reactions. Larry and Claire, thanks again for the opportunity.
Well, and thank you for just wonderful presentation. As an American, of course, I can only wish you well on NAP 2.0. Yes, anything to get away from NAP 1.0 at this point would be extraordinarily welcome. I would sacrifice vegetables and stuff to your image. We are running a little late, but we do have time for a couple questions. Anil, I promise we won't eat into your time very much. If there are any questions that you have, I've got a little one and a comment, and my comment was in the news yesterday, and it involved the Cuban government and the war in Ukraine, and forced labor. The Cuban ministries have come out with a statement referencing their efforts to squash what they call privatized efforts at forced recruitment of migrants into Russia, mostly Cubans, to fight in Ukraine. And are very worried that what we're seeing, and so people are now worried that what we're seeing is a shift in the focus of forced labor from the usual children, sexual exploitation, and exploitation of workers, to one in which we are going to see forced recruitment, both into, directly or indirectly, into state operations, some of which may have significant human rights implications. And into the networks of non-criminal, non-state actors and enterprises. And I don't know if this is something that the Americans are worried about. And my second point is, in a number of developing states, there's this line between inside and outside with respect to due diligence, and that these due diligence laws and due diligence applications applies to the overseas operations under the control of a U.S. company, but that inside a different set of rules, including potentially the non-application of due diligence, applies. And I don't know if that's the case with the U.S. So those are just the 2 points I raised for you.
Yeah, let me, on the second, I'm not going to try to answer it now. I want to give that some more thought. I'm not sure I have a brilliant answer to it. It's an interesting point that I want to consider further. On the first, I think it's the best I can offer is, I think to date, Russia sanctions have proceeded along a very different path than sanctions directed at Xinjiang. I mean, Xinjiang was easier in the sense of, there were the documentaries, there was the analysis, a reliable documentation of what was happening specifically with regard to potential supplier factories and our farms that could find its way into supply chains, so there could be targeted focus. To date, the Russia sanctions, and don't take my word for it, there's a group of businesses and others called Business for Ukraine that has noted the need to take a look at existing sanctions and consider some of the newer developments, which have really not been part of the analysis to date. And I think that could be what you shared would be part of that, but it's not currently being addressed.
Okay. All right. Thank you. Any other really quick questions? All right. Oh, Claire?
Yeah, just thanks a lot, Eric. One thing that I'm curious about, we always, of course, touch on the California supply chain transparency legislation in discussions of, due diligence or quasi due diligence statutes. And I wonder, and, simultaneously, we hear quite a bit now about debates, let's say, about ESG investment criteria and human rights related investment criteria at state level in the United States. But we don't hear, or at least I'm not aware of, other initiatives or statutes at state level addressing due diligence or transparency requirements. So, you know, what's the state of play there, and what would you rate to be the prospects of further either indirect due diligence regulation via transparency requirements addressing due diligence practices, or, you know, even direct due diligence duties imposed on companies, or again indirectly via investors at the state level?
I would, just to be very quick in answering, I think there's a significant appetite in many states, and indeed in even localities, to try to play a role in addressing concerns, particularly of investor based organizations. But there's also kind of the cautionary note of whether in doing so they may be creating something of a bureaucracy without necessarily changing the landscape dramatically to achieve the underlying goals. So I have not, it's been probably about 2 or 3 years since I last, read a survey of what was being done at the sub-federal level. And I think, there are certain municipalities in particular that not unexpectedly have tried to champion this, but the first round of efforts was less than fulfilling for some. So I think it's still a very open question whether we're going to see a lot of new initiatives at the sub-federal level. That's probably the best I can offer at this point. It'll also be a key signal whether the federal government in its national action plan certainly can refer to and encourage, if it wishes to, sub-federal measures. And it'll be interesting to see if this national action plan talks about some things that are happening below the federal level and provides any guidance to mayors, city councils, county commissioners, and state legislators and others.
Well, thank you very much. This was a fabulous presentation. We're running a little late, and I think that what we might do now is give the floor over to Anil. Yes. And thank you, everyone.
Thanks a lot.
Shall I go on?
Yes, please.
Is it my turn? Thank you
It
so
is your
much.
turn.
Thank you, Claire and Larry, for organizing this and including us, me and Rachel. Rachel couldn't be here today, unfortunately. So she sends her apologies. I also have to leave before 5 to pick up my 2 kids. So I'll do my best to be on time and stay as long as possible. Our chapter, as we've presented before in the earlier workshop, looks at the interaction between human rights due diligence and disclosure regimes, reporting regimes. I will use reporting and disclosure interchangeably. And I think we need to be more consistent in the paper, in the chapter, on our terminology, but we keep going back and forth between the 2 terms. So what we are doing in our chapter is that we analyze the role of human rights reporting requirements in the evolution and legalization of human rights due diligence regimes. We've received some really useful feedback from Larry and Claire. Thank you very much. And we're reflecting on how to integrate that in the paper. We're working on it, but we've been delayed because of certain medical issues that we faced in the past few weeks. So what we do in the paper is that we observe the seeming progression of legalization of business and human rights norms from disclosure obligations to process obligations in the form of human rights due diligence. And we reflect on the enduring role of disclosure within human rights due diligence laws, but also as standalone obligations in places like the United States, but also even in the EU, where now a separate regime is being developed for human rights due diligence through the Sustainability Due Diligence Directive, and then the updating of the non-financial reporting directive through the Corporate Sustainability Reporting Directive. So there's still kind of, they're not integrated in that sense, although there is reference to each other in each directive. We are, after receiving Larry and Claire's comments, we started thinking about this progression from reporting towards human rights due diligence because of the questions that you asked, Claire and Larry, basically. And we realized that there's not a linear progression. There's kind of a more non-linear, basically, situation going on. And then we are also reflecting back on how far down the line we're going in terms of looking at disclosure requirements that have been included in domestic company laws or domestic securities laws on issues of social performance, social impacts, environmental impacts, etc. But for the moment, what we're doing is, in the paper, we're looking at a select number of disclosure laws that specifically focus on human rights disclosure or modern slavery disclosure or labor disclosure, forced labor disclosure. And we're also looking at the recent wave of human rights due diligence laws, not the sectoral or thematic ones, but the ones that are more general, like the French law, the German law, the Norwegian law. And we're going to add reflections on the European directive as well, on corporate sustainability due diligence. But we haven't yet delved into that in the paper, but that is on the agenda for us. So we start by reflecting on how human rights, sustainability, or ESG type disclosures are governed or guided by a web of hard law and soft law instruments. And we observe that some large companies end up being captured by multiple disclosure laws and frameworks at once. We don't really delve into this, but I think this is an area in which practically we're going to have to think further about going forward in terms of practice, corporate practice developing in this area, and companies having to comply with different due diligence law, different reporting requirements that they are captured by in different jurisdictions, as these are multiplying around the globe. The chapter is basically divided into two main parts. In the first part, we discuss the role of human rights due diligence within laws that require disclosure, but laws that do not require human rights due diligence. They do refer to due diligence, the ones that we're looking at, with the exception of one, as part of the process that would lead into the disclosure, that would feed into the disclosure, I'm sorry. But there's no requirement that companies actually carry out due diligence. At the moment, the paper is looking at the Dodd-Frank Act. We look at the California Act. We look at the UK Modern Slavery Act, the Non-Financial Reporting Directive from the EU, and we look at also the Australian Modern Slavery Act. Although we are revisiting that in light of the comments that we've received from Claire and Larry to see whether we need to extend the scope of this analysis or whether we need to actually narrow it down. We need to make a decision on that soon. But the gist of our argument is that before the recent wave of human rights due diligence legislation emerged in Europe, particularly in France, Germany, Norway, and the Netherlands through the child labor due diligence law, the first attempts to legislate human rights responsibilities of businesses were done through disclosure and transparency requirements. Obviously, human rights responsibilities of businesses are regulated through labor laws, health and safety laws at domestic level, but specifically referring specific references to human rights responsibilities or human rights issues in general was lacking. And more so, those that apply throughout business operations, not just domestic performance of companies, but those that cover their subsidiaries, their supply chain relationships. So this is the focus, obviously, of our analysis. So when we look at the human rights disclosure provisions in the Non-Financial Reporting Directive, EU's Non-Financial Reporting Directive, and the UK's Modern Slavery Act, these laws ask information disclosed to include information on due diligence processes, although companies can disclose information that does not contain their due diligence process. They might not, there's no requirement that they should actually engage in due diligence, but that if they do, then they should disclose this information. It was expected, since there's reference in the law that due diligence would be included in the reporting. It was expected by several of us that companies would actually carry out human rights due diligence to identify issues, develop mitigation and prevention measures, and remediate harms, and then report on these. There's a mixed picture. Studies looking at reports being submitted under the UK's Modern Slavery Act, but also under the Non-Financial Reporting Directive, give us a mixed picture as to how far companies really communicate their human rights due diligence policies and actually the issues that they've identified or mitigated or prevented, or the remediation measures that they've taken. The idea behind, obviously, transparency and these transparency requirements is that if companies have to be transparent, then they would reflect on their own performance, and then they would start doing better. They will be compelled to improve their performance due to market pressures, to be better corporate citizens. We note that these laws have not achieved great strides in improving corporate respect for human rights, but they were, we argue, instrumental for setting in motion the legalization of business responsibility to respect human rights via domestic legislation. Really baby steps, but we do mark their importance in the paper. There is evidence that these laws have improved the quality of reporting in some instances, though we have not come across any evidence that actually better quality reporting has necessarily led to improvement in corporate respect for human rights and the impacts on communities or workers down the supply chain. Another kind of, we look at the different types of, we reflect on the different types of legalizations as it was in the concept note for this book, different types of legalizations that corporate disclosure frameworks could have led to or may lead to in the future. One thing that we discuss is the new avenues that disclosure laws provided for affected communities to seek accountability. Not groundbreaking, but they have provided access to information of some sort, at least to criticize corporate conduct. So NGOs, investors, and consumers can obtain information on corporate human rights policies, even if those policies are inadequate. And this information that are publicized through reports, corporate reports, helped show courts in certain instances, like the cases of Vedanta and Okpabi and Shell, the relationship between a company and its suppliers and subsidiaries. So it was helpful to demonstrate to court and convince the court that actually these companies are reporting publicly that they're taking certain steps, that they have issued guidance to their subsidiaries. So those were facts that that would have been more difficult to obtain without the presence of those reports. There is potential drawbacks. There's been arguments that courts relying on these reports would urge companies not to disclose information in this way. They might be less transparent, but the more these laws compel companies to disclose, the stronger the disclosure laws become, the harder it will become for companies to actually not disclose the information. So our overarching observation in this section was that despite the move towards laws containing more substantial obligations on corporate respect for human rights by mandating human rights due diligence, these laws that focus solely on disclosure continue to be relevant, particularly in jurisdictions where political will for a human rights due diligence law is lacking. We note the limitations of these laws in the paper for improving corporate respect for human rights. And then we conclude the section by discussing some options to strengthen these laws when human rights due diligence laws are not a feasible alternative. And these include provisions that prescribe specifically what type of information that should be disclosed, requirement of compliance rather than comply and explain approaches that are being adopted in some of these laws, and the necessity to have regulatory oversight and enforcement, regulatory oversight and enforcement to compile compliance. We are now adding a section on the European Corporate Sustainability Reporting Directive, the new directive, which is actually introducing some promising reforms in the respects that we identify. In the second part of the chapter, we look at the disclosure requirements within human rights due diligence legislation. Going back to the UNGPs, we all know that they clearly state that companies should communicate externally how they address their human rights impacts, including, not exclusively, through formal corporate reporting. And communicating human rights impacts, policies, and measures is an integral part of the human rights due diligence process, as laid out in the UNGPs. So in the second part of the paper, we look at human rights due diligence legislation from France, Germany, and Norway to discuss the evolution of human rights reporting requirements within these domestic laws. Although all three laws that we're looking at were introduced within the last 6 years or so recently, they are far from identical in many respects. They're different than what the UNGPs contain when it comes to human rights issues. Naturally, they're a bit more specific. So we specifically zoom into the reporting requirements under each law. We're not assessing them in general, but we're looking at what role reporting plays within those human rights due diligence laws. Roughly, each law imposes a requirement to conduct human rights due diligence and periodically report on human rights due diligence information, including policies, processes, impacts, and risks identified, and actions taken to address adverse impacts and prevent or mitigate risks. They do prescribe consequences for failure to comply, although these are different in each law. So we do reflect on the fact that we can expect contents of the reports that are linked to the human rights due diligence laws to contain information that is more comprehensive than those that we see under disclosure laws, although this is simply projection. We would love to see a study, or we would like to do a study actually ourselves, looking at how French companies were reporting before the French law on due diligence entered into force and how they're reporting now. There's obviously the other two laws that we're looking at are relatively recent, so there isn't the same amount of material to look at, but it would be interesting to see how companies have evolved in terms of their reporting practices when it comes to human rights reporting after having these laws applying to their business. But even though there is promise, there is also still concern around the adequacy of these reporting obligations within human rights due diligence laws to actually improve corporate respect for human rights. That's obviously the ultimate goal. The ultimate goal is not human rights due diligence, it's improving corporate respect for human rights. And so we're looking at how far these reporting obligations contribute to that. The first concern we have pertains to the formulation of reporting obligations within human rights due diligence laws regarding the specific information required for disclosure. Concerns have been raised that where reporting rules are general and vague, they're unlikely to lead to meaningful disclosures from a human rights perspective, even if reporting is attached to human rights due diligence. There is obviously a lot of debate around what is expected from companies when it comes to human rights due diligence itself. So then the reporting becomes, the reporting issues become attached to that uncertainty. There are also concerns around the adequacy of oversight and enforcement provisions included in human rights due diligence laws to ensure completeness, quality, and accuracy of human rights disclosures made under these laws. The human rights impacts that are addressed through the human rights due diligence process are obviously complex, sensitive, and may span multiple layers of a company's supply chain and own operations. The value of disclosures is particularly prominent because of the marked information asymmetry between the company and external stakeholders such as communities, investors, and consumers. And it's crucial for human rights due diligence laws to obviously contain safeguards to bridge this information gap and legally prescribe robust mechanisms to sanction and remedy inadequate and inaccurate reporting of HRDD. If simply having a requirement that companies must carry out human rights due diligence and must report on it without having the necessary mechanisms to make sure that these are being done adequately is not going to improve the situation further than what we're experiencing right now. We look at the French law to understand how French law has been operationalized in this context, as it's the longest serving law, basically the longest in force, the one that's been enforced for the longest period. And its implementation up to date has demonstrated that companies may fail to develop or publish a vigilance plan, or they may omit including certain key information on their human rights impacts, and face little or no consequences for breach up to now, even though under the French law, external stakeholders can monitor, can file a notification to the company of their concerns. And if the concerns are not resolved, then they can file lawsuits to trigger the statutory consequences of having an inadequate vigilance plan. But so far, as we've all seen, the court procedures to enforce the French law have encountered certain obstacles around questions of jurisdiction and admissibility. That doesn't mean that these aren't going to be resolved in the future, but it is at the moment making it very difficult for external stakeholders, for communities or civil society to operationalize these transparency duties and these provisions for enforcement. But we do come back to a more positive note. Published vigilance plans have still been instrumental to the efforts to ensure corporate compliance with the vigilance duty. It's kind of the interface between the public and the company. Contents of these reports provide civil society actors with information on the adopted vigilance measures or their lack or the lack thereof, allowing an assessment of how far the reality on the ground corresponds with the reported measures in the vigilance plan. If plans are inadequate or inaccurate, relevant parties can issue a formal notice to comply with the law, and where this fails to initiate, they can initiate judicial proceedings to compel compliance. The vigilance plan also acts as a first port of call to identify whether human rights and environmental harms resulting from the company's operations could have been prevented or mitigated had the company fulfilled its vigilance duties. And failure to develop, publish, and follow a vigilance plan could give rise, and if any harms occur as a result of this failure, this can give rise to civil liability, obviously, but we don't really look at that in detail. But what we're doing is just kind of linking the role of the vigilance plan, which is what the company publishes and discloses, with the legalization through civil liability or the procedure of the judicial proceedings to compel further compliance. So our conclusion is that reporting under these laws that have emerged recently, these human rights due diligence laws, basically triggers a chain of events that is essential for a meaningful and effective legalization of the human rights due diligence process. We quote a short passage from a paper that was published in the Business and Human Rights Journal by Gabi Quijano and Carlos Lopez, where they observe that the battlefield has now shifted from debates around mandatory versus voluntary human rights due diligence to discussions about the nature and scope of legal requirements and their relationship with legal liability. And I think that's where we're seeing, at least in Europe, that's where we're seeing the really big part of this debate, and that includes the role of disclosures and reporting. I'm going to just end it there. Thank you very much.
Well, thank you for just a magnificent discussion of the complexities that you and Rachel are weaving together. It was really quite good. I've got like a zillion questions, but I don't want to ask them. And hopefully, if there are others here who've got questions for our attendees, if you can use the Q&A function to write your questions, we can get to those as well. So I invite questions before we move to our next panelist, Eric Miller. Questions? Anyone? Well, while they're formulating, I have a question for you. I've been looking at, and disclosure has become, it used to be such a simple little thing, and now it's become this big complicated monster, especially when disclosure is wed to information and information flows. So the question I have, and this has only dawned on me fairly recently because it was thrown in my face in another context. It's one thing to mandate disclosure. It's another thing to rigorously review disclosure for, and now I understand there are three evils: mis, dis, and malinformation, and then to empower either a regulatory body or individuals to seek some sort of, not punishment, but some sort of disciplinary action and perhaps compensation to the extent that this information in a disclosure statement causes harm. To what extent do you see, and this has become very prevalent in other areas, not in connection with disclosure laws, but in connection with the control, with the protection of integrity of particular social relations that are grounded in information. So I'm wondering, to what extent do you either see this coming, or do you think that this may be something that may be worth considering in disclosure regimes?
Thank you, Larry. Absolutely. I think this takes us back to the presentation of Birgit, who talked about the practicalities of and difficulties in actually enforcing the German law and how it's a much bigger mess than expected. And I think it is complicated to expect that there is going to be a rigorous review of this information, especially if we're looking at institutions that are overseeing, regulatory bodies that aren't properly staffed or resourced. But even if they were, in the ideal world, it's a complex web of issues that we're expecting companies to report on. So I guess, like everything about human rights due diligence, this is one thing that we are going to see as we go and find solutions to the problems that it creates as we discover the problems in this context. So sorry, I don't have a great answer, but it is an important aspect of this to reflect, because we expect companies to publish more and more information. But going back to the issues that were discussed in the morning, there are data implications, there are various different implications that are involved in all this. So it's important to look at the bigger picture and properly assess the consequences of creating this source of information.
Thank you.
Thanks.
Thank you. Brilliant. Other questions for Anil? Questions? Claire.
Yeah, thanks, Anil. Of course, I've had the benefit of, reading your paper in draft before today, but something I didn't really think about when I was doing that, but I have just thought about is, the perhaps, missing piece of the picture that we haven't touched on so far is the development of reporting frameworks. And, reporting frameworks and the initiatives, underneath them, and the institutionalization of reporting frameworks like the GRI, have themselves undergone a quite complex set of transitions and evolutions in the last 20 years. There was a sort of moment when it seemed like, GRI, for instance, had critical mass, but it was superseded by a number of other initiatives that have broadened in scope in parallel to the rise of, responsible investment concerns, which have, taken non-financial reporting from being a bit of a boutique interest out to the sort of mainstream of the accounting profession, and and the disciplines and metrics that they use. And of course, we see some competition also between the US sort of based accounting standards, European now sort of rearguard action around the taxonomy and all the regulation associated with that. So I'm not expecting, any sort of particular analysis or, immediate response on this, but I think it's an important piece that we don't see so much when we only, look at the face of the legislation. The legislation and, as a piece of kind of law and context, I guess, requires us to, look also at these quite significant mobilizations of different professions and practices. So I guess more of a comment than a question, but invite your reflections on that piece of it.
Thank you, Claire. We did actually receive this question previously, not in the context of this paper, but in the context of another piece of work. And it is despite it being so relevant to all this, it's a whole different world that we are not actually familiar with, neither Rachel nor I. But it is important to, I guess, increasingly integrate the research and the research on these frameworks and these frameworks into the discussion here. And when we look at the newer laws, human rights due diligence laws, but also the corporate sustainability reporting directive, they are going to be more prescriptive. They are being more prescriptive about how the reporting should be and what should be reported on. So I don't know if there's going to be a divergence from those accounting industry-led really frameworks and these human rights due diligence reporting kind of practices. But it is, yeah, it's really important to reflect on that, but I don't have any immediate answers. But we will, I've made a note and we will look into that. There's a question in the chat. I'm gonna just read that.
Right, from Anna Prada. Yes, if you can read that and then answer it briefly. We're running a little late, but thank you.
Yeah.
Yeah, and I'll read it aloud. I find it a very interesting topic from my perspective. Working in ESG reporting practice, I always see that companies give more importance to measurable issues such as environmental matters. I think it's important to work on the development and implementation of human rights issues, and that they do not remain only in policies that companies do not know how to put in practice. How do you think we can make progress on this? For example, is there talk of social taxonomy in Europe, but it has not been approved?
Yeah, I think this links to Claire's comments that the frameworks, the reporting frameworks, do provide some level of criteria and some measurable guides, but it is, I guess, inadequate. And what I've seen in the corporate sustainability reporting directive draft is that there is a reference to the EU taxonomy. So I don't know how that is going to all link together. We're just looking into the European directive. We've just started looking at that more closely. But yeah, I think it's always going to be key when we look at human rights reporting, to have, on one hand, I think it can be a trap to have measurable indicators because of the nuances and the complexities of human rights issues. But on the other hand, it's really difficult for companies to know what they're doing and have some level of certainty without having, some measurable indicators. So I'm not sure where I stand on this, but I think it's not as easy in other fields to have a formula, a prescription on what companies should report and how they should report it. Thanks.
Well, thank you very, very much. I know we're running a little late, and I really appreciate your patience and Patrick's patience. And you are on. If you could introduce yourself a little bit, and then your presentation, that would be fabulous. So you are on.
Hi, everyone. I'm Patrick Miller. I'm speaking on behalf of a couple other members of the working group, the ABA Model Contract Clauses Working Group. It's myself and Sue Maslow and David Snyder who've been involved in the Model Contract Clause Working Group since inception. They're really like the parents of the Model Contract Clauses, if you will. And I joined the Model Contract Clause Working Group around 2021 after version 2 had been produced. And I've been involved in the efforts to promote the Model Contract Clauses, implement the Model Contract Clauses in companies, and speak about the topic. So I really thank you all for having me on today. Just to give you a bit of background on myself, I spent the first 10 years of my career practicing international commercial arbitration at larger law firms. Then I settled out here in Los Angeles and started my own firm, Impact Advocates, where we focus on doing dispute resolution, particularly for social impact companies, B Corp benefit companies. But then in the context of our kind of international commercial practice and also our responsible business practices, we naturally gravitated towards responsible supply chain initiatives, particularly the MCC working group, which is how I'm finding myself here today with a lot of scholars. So I'm a little bit intimidated right now as I'm a practitioner. I'm not an academic. I don't even remember how to blue book. So please don't ask me any of those questions. Let me just describe a little bit about what our chapter is on and give you a bit of a rundown of how we see it. We just received comments from Larry and Claire, a lot of different red lines, so we've got our work cut out for us, but we're looking forward to it. So for those of you who might not be familiar with the model contract clauses or the ABA working group, it's effectively grew out of an idea of David's and then was spearheaded by Sue to develop a set of template contract clauses that could be modular and could be incorporated in companies' international supply agreements as a set of clauses aimed specifically to address human rights issues in the supply chain. The kind of genesis of the idea, the kind of introductory concept was the idea of putting process defects, so issues like human rights abuses, on the same level of product defects. So the quintessential example is a perfectly stitched soccer ball that meets all of the product criteria, but it happens to be stitched by child laborers. So how do we make it a contractual mechanism so that that good would not be allowed in the stream of commerce? So the idea was to bring together a lot of business law lawyers, transactional lawyers, as well as human rights professionals to put together a series of clauses that incorporated the best practices in business transactional law, while also addressing the best practices in human rights due diligence, remediation, things like that. So version 1 of the clauses was produced, I don't know, let's say 2018. I honestly don't remember. And then that was met with a lot of further contributions from the advocacy community and the academic community that noted that a lot of the obligations are still one-sided, and that many of the obligations, similar to the traditional regime of supplier codes of conduct, a lot of the obligations are one-sided on the supplier's part. And in the context of responsible supply chains, it's important for the buyer to have an appreciation and an understanding of how their purchasing practices contribute to the incidence of human rights abuses. So that gave rise to the version 2 of the model contract clauses, which was spearheaded by Sue and David, as well as Sara Dedouche and Olivia Wyndham Stewart, who are also members of the working group. So they produced version 2 of the model contract clauses, which I actually do know was released in 2021, and it included several clauses which put responsibilities on the part of the buyer. And one might think that it's unlikely that companies, particularly buyers, would want to include clauses in their contract which give them responsibilities. But oftentimes these responsibilities are no more than what would be expected from a normal responsible supply chain relationship. So for instance, there's a clause which requires the buyer to have an understanding of how their how their pricing terms will affect the incidence of human rights abuses. And in the context of kind of traditional sourcing practices, and we'll get into this analogy a lot, where we make an analogy to ingestible products. If I was purchasing lettuce and a supplier told me I'm not going to be able to meet that price unless I use lettuce that has a high probability of having E. coli, I would say, okay, well, I don't want to purchase that lettuce. I'll need to get a higher price. Similarly, if a supplier tells me there's a high likelihood that I'll have to utilize suppliers in my supply chain that utilize forced labor or prison labor, we'd say, okay, well, we have to come to a different understanding on price. So that's a little bit about the MCCs, and particularly version 2, and I'll go back to them in a bit more detail, but I do want to be conscious of time and everything like that. A large part of our book our book chapter rather, there is Sue and David would be upset if I didn't mention the fact that they did just release a whole book on the MCCs that was published by the ABA. So you should purchase it alongside Larry and Claire's book, which will come out next year, I'm sure. But the large part of our book chapter, at least the introduction, talks about how the overarching concept is that contract terms can legalize and operationalize human rights obligations in a way that that human rights due diligence regimes or strict liability regimes don't have the same effect, because they actually implement the responsible supply chain regime in the contractual relationship itself. So it gets down to the way the parties do business. When the MCCs were first launched, and you can see it was before the wave of human rights due diligence regimes and the more robust enforcement from the likes of Customs and Border Protection in the US. So at the time that they were released, the thought was that these contractual terms can effectively implement law, as it were. Now we've kind of shift focus more towards the fact that these model contract clauses are tools that companies almost effectively have to utilize in the context of their compliance frameworks for either the strict liability regimes or the human rights due diligence regimes. We say that the model contract clauses are preferable to the old regimes of just traditional representation of warranties or unilateral supplier codes of conduct, because they make these responsible supply chain commitments legally effective and operationally likely. And those are important terms, particularly, as I mentioned, the MCCs were released before there was this need for companies to implement complicated compliance frameworks, where our argument used to be to companies, you should implement these clauses because you have these responsible supply chain pronouncements on your websites. If you really believe in implementing those practices effectively, you need to implement something like a MCC regime or something along those lines, something that's more effective than the supplier codes of conduct, which we've come to find have serious deficiencies. So the idea is that these are more legally effective and operationally likely than the supplier codes of conduct, because oftentimes they can devolve into those supplier codes of conduct can evolve into tick box exercises. But the idea with implementing the MCCs is that it would come about through a process where the supplier realizes that these obligations are enforceable, and so they make sure that the terms of the relationship are such that they'll actually be able to abide by those terms. It's not just simply signing away and having no thought to implementing the obligations. And on the part of the buyer, it's not like they just let those clauses be signed and have no interest in enforcement. Now, there's an interest on the buyer to enforce the clauses, and there's an interest on the supplier to enforce the buyer clauses, but also to uphold their obligations, because they're more focused on the fact that enforcement is more likely given the nature of the human rights regimes around the world. Yeah, so the idea is they were important before the human rights due diligence laws. Now they're essential. We say that a couple of different reasons why the MCCs are more operationally effective is because it allows for issues to be uncovered and discovered without immediately triggering a breach. Rather, the MCCs focus on a remediation first framework. So since they don't initially trigger breach and damages, it allows for the issues to be uncovered. It also allows for this idea of Kaizen, continuous improvement. And oftentimes in the context of human rights due diligence, we have to understand that the status of today isn't where we actually want these parties to be at. We want them to get on a path towards improvement. So the MCC framework allows for that. And then it also allows for the fact that if remediation is impossible, there are certain so if either remediation isn't properly implemented, or if there is kind of a violation of what we call zero tolerance activities, and that can be defined by the particular buyer. This speaks to the fact that the clauses are modular; they can be individualized to the particular buyer. So if one company says that child labor is a zero tolerance activity, then that can trigger a breach automatically. Whereas as other companies might say, well, we don't think child labor is a zero tolerance activity. We think that that's an issue that can be remediated in the context of the overarching remediation framework. Then that's for them. We note that the allowance for rejection and damages in that context, if it comes to that, means that companies are more motivated to remove those products from the stream of commerce. So if I'm a buyer and I discover that there are process defects with respect to my products, and I have commitments to a customer down the road, I might feel like I have to sell those products onto that customer because I'm not going to be able to recover whatever damages I'd see from lost sales. But if you have these contractual mechanisms, you can say to myself, no, I don't want these products to continue in the stream of commerce, or perhaps USCBP or some other regulator would not let me put these products in the stream of commerce. Therefore, I need to recover damages downstream or upstream. I always forget that. I guess your supplier is upstream. Anyways, the key issue is that this is a tool that companies can use in their toolbox towards developing a compliance regime with either the human rights due diligence regime and the strict liability regimes. And just to be clear, I think I've said it probably 6 times. When I refer to strict liability regimes, I'm speaking of regulatory approaches like the U.S. has taken, where they have Section 307, which prohibits products produced using forced labor from entering the company. So it doesn't matter what type of human rights due diligence processes you put in place. It's a strict liability effects driven legislation, whereas a lot of the approach in the EU, and I don't have to tell anybody here, is more related to the process of conducting appropriate human rights due diligence. So the next part of our chapter discusses how the differing legislations require contractual clauses. And just to be clear, we say contractual clauses, we think that the MCCs are particularly suitable set of clauses because they incorporate best practices from contract law and human rights law. They effectively, we say they operationalize the UNGPs. But we're cognizant of the fact that the MCCs, at least the initial drafts, were produced in large part through American lawyers who are focused on UCC contractual terms and the CISG. Now that we have a lot of these EU human rights due diligence laws, there's an active push with our colleagues in Europe to develop contract clauses that are more aligned towards a civil law regime. So that is in the works, and we are thinking through that. But the idea is that the human rights due diligence laws are requiring either explicitly or implicitly contract terms. Now, for instance, the German Supply Chain Due Diligence Act actually explicitly requires contract clauses, and we've written some great articles with our colleagues in Germany that have pointed that out. Similarly, we'd say, for instance, the duty of vigilance law in France, it doesn't necessarily require explicitly that parties implement contractual clauses, but the potential for civil liability certainly motivates companies towards implementing effective responsible supply chain regimes. And to the extent that having enforceable contractual regimes similar to in line with the MCCs is more effective, that implicitly effectively motivates companies to implement those clauses. Now, with respect to the U.S. context, we're actively working with regulators like Customs and Border Protection on how the MCCs will be helpful to companies in implementing a compliance regime. So particularly, we've thought through how the MCCs are helpful for companies to obtain reliable, credible information that they can provide to CBP in the context of an applicability review. So for those of you who aren't experts on the UFLPA, just very quickly, the Uyghur Forced Labor Prevention Act provides a rebuttable presumption that products that have a nexus to Uyghur labor. So if they were produced in the Xinjiang region of China, or they were produced by any of a set of listed prohibited companies, those goods will be presumed to have been produced using forced labor. And if a company wants to import those products, they would have to rebut that presumption by using a clear and convincing evidence, right? So that's what's called an admissibility review. So can these products, which are subject to the rebuttable presumption, be admitted into the country? There's also what's called an applicability review. And just to put a button on that, given the difficulty in obtaining reliable information from products that are manufactured in Xinjiang and the clear and convincing standard, I don't think there's been I'm pretty sure I'm almost sure there hasn't been a company that's actually rebutted that presumption. It's very rare that companies are even attempting to rebut the presumption. So admissibility reviews are not where a lot of the action happening for. What's happening is that companies are trying to undergo what's called an admissibility review. So, I'm sorry, an applicability review. So what they're trying to argue is that the UFLPA rebuttable presumption is not applicable to these goods because they don't have a nexus to Uyghur labor, i.e. no component in this shipment was produced in Xinjiang or by one of these listed entities. So in the context of an admissibility review, what ends up happening is the company that has products detained by CBP submits a set of documentation to show a supply chain tracing throughout the supply chain of all the components of their product to show that there's no Xinjiang connection. And that admissibility review, there's no rebuttable presumption, there's no clear and convincing standard, but CBP still is going to require compelling, reliable information in the context of this review. And so if the most of that information is going to be provided by the supplier and the supplier's suppliers. So if that information was obtained through a framework of enforceable contractual clauses, which require the information to be accurate, that will give a lot more credence to the accuracy of the documentation that's being submitted and will make for a more compelling admissibility case. That got into the weeds a little bit more than I expected, so sorry about that. And then, of course, another key area where the MCCs come into play in the context of your compliance framework with the UFLPA is you'll have a basis for potentially terminating relationships with suppliers that appear to have connections to Xinjiang, or you'll have conducted the due diligence sufficiently such that you won't engage with suppliers that have connections to. So those are some of the key reasons why the different legal regimes effectively require model contract clauses. I haven't been monitoring the time, but it's been plenty of time, so I think I'll stop there and be happy to entertain any questions.
Well, thank you very, very much, Patrick. That was actually quite helpful. You answered a ton of questions that I'd prepared for you. You anticipated them, so that was very useful in an area that people who are focusing on the flows of information and disclosure may be less aware of contractually based provisions like this within micro-ordered private law. It's certainly a regime which is very different from the kind of public law-oriented regimes that are being built everywhere else. And I'm happy to open this up to questions. I've got 3 questions in the form of 3 words for you. If they're very short, each question is 1 word. And maybe I'll start with that. Word number 1 is public. Word number 2 is, well, it's 3 words. Sorry, I just ruined that whole thing. Third-party beneficiary, and word number 3 is agency. And those are the questions that came to mind as you were going on describing this, because you're describing a private regime, and it's kind of ironic that it's a due diligence regime that, because of its construction within contract, is likely to be private, unless there is an additional layer that requires disclosures of these private contractual provisions. The second one is, of course, the thing that makes Americans nuts and makes American lawyers rich, and that is third-party beneficiary issues around these provisions. And of course, the second one, the third one is what makes all kinds of companies scared, and again, lawyers rich, and that is the agency issue when you're dealing with the close collaboration of at least legally autonomous bodies. So there you go.
Okay, yeah, those are so the first one's a bit easier, and I have a nice little fun anecdote. Second one are definitely thornier. So the first point is that you're right to comment on the fact that this is effectively a private kind of regime between private parties. And I actually was kind of guided towards the model contract clauses and this kind of thought process because I read an article from David back when I was in law school, like a million years ago. I'd read an article that he'd written about how contractual regimes can effectively implement legal rights. And so then 10, 12, however many years later, I find the model contract clauses, which is kind of the evolution of his thinking at that time, and was really geared towards it, focused on it. So yes, it's a kind of private regime where you can hopefully help implement public policy. So there's that point. The second point you had was with respect to third-party claims. Now, and we mentioned in the article, I look at a lot of these issues from the standpoint of a disputes lawyer, because most of my colleagues in the working group are transactional lawyers, where I'm looking at it, how would these clauses be enforced? How would I, as an arbitration practitioner, advocate for one side or the other? So the clauses specifically disclaim third-party beneficiaries. That's the standard. Whenever we're advising companies on implementing these clauses, we explicitly mention that. We say that there's a reason for this. If you don't want to disclaim these, you don't have to disclaim third-party beneficiaries. But the point is, this isn't giving rights that those third-party beneficiaries can then enforce. One kind of practical issue that I've noted that if you were ever actually going to bring any type of arbitration, let's say that you have $1 million shipment that you have to scrap, so you do have to sue the supplier, let's say it's a supplier breach, you'll probably want the affected stakeholders who are the victims of whatever abuse to be involved in the arbitration, because they're going to be the ones who can give you the evidence to that. So you might want to have some type of mechanism for them to have some rights, but the rights will not come from the contract itself. They'll come from whatever other terms are out there. But so that's one point. Now, with respect to agency, that is the footnote that whenever I'm working with companies and implementing the clauses, I'm teaching. Oftentimes, I'm working with lawyers that haven't been doing this for a while, or non-lawyers, and I say it's very important to read the footnotes. Footnotes are very important. So in our draft clauses, we have a very pregnant footnote that mentions the fact that in many different regulatory contexts, in the UK, the idea of creating a framework where the buyer has such substantial control over the supplier could potentially lead to an argument that the supplier is an agent of the buyer, that the buyer has a duty of care to those workers because they maintain such control over that buyer. So for instance, the footnote comes up in a clause which says something to the effect, and I don't want to butcher it very much, but the idea is there's a clause that says if we discover a a violation, you should, fire that sub-supplier or fire the employee that did this, blah, blah, blah. But then it notes that if you include something that's this prescriptive, then you open yourself up to a charge that you have control over this buyer. Oftentimes, well, maybe not oftentimes, but when this came up very recently, I said, look, no matter the clauses, when a breach is uncovered or when an issue is uncovered, the clauses provide for the parties to implement a remediation plan. It's incredibly unlikely that a remediation plan will be developed where an offending employee that's harassing workers or sexually exploiting workers or an offending supplier. It's unlikely that a remediation plan would be acceptable by both parties where that issue wasn't addressed. So you don't need to have this contractual mechanism to do it as specifically. But so that's kind of the company side where you're really thinking through limiting the liability of the company that's going to be incorporating these clauses. But on the flip side, we've had people that say, look, with the way the status of the laws as they are, companies are going to be on the hook either way on one way or the other. So it might be better for you to have sufficient control so that you can reduce your exposure to these damages. So that's kind of, different people have different philosophies on that.
The reason I mentioned the last one is, of course, it gets very tricky when you're dealing in sanctions-based regimes, as you mentioned, like the Xinjiang case, where in fact, if you do wind up assuming that kind of control, either specific or general, you may wind up being the bearer of the sanctions that may be imposed by administrative agencies, as well as open yourself up to lawsuits.
Oh God, could you imagine a U.S. company getting on an entity list or something like that?
Yes, it is. It is possible. It is possible, and that's why my eyebrows twitched a little bit when and what you're doing in a sense is relying on the lawyering skills of counsel who are negotiating this on both ends. But one always worries, especially in the context of disclosure, because this thing will come out. What happens if you guess wrong, and ought there to be some kind of either a disclosure safe harbor or some kind of reporting mechanism so that you would be obligated to report, but you might, and so a second order due diligence or disclosure mechanism, but then you are not either in control or enmeshed in what can be a very high risk enterprise, especially in the context of sanctions.
It's very, very difficult. So for instance, if you discover that there's forced labor, if you're in a Section 307 regime, you can import that. If you know that it's produced using forced labor, you're not able to sign off on the customs regime. So
right, but do the clause provide you with the right to then disclose this to enforcement agencies, for example, in the federal government or in state governments, if that triggers your actual knowledge of a violation of either a sanctions-based rules at the federal level or a trafficking or other sectoral prescription at the state level?
Well, to be honest, I don't think there's anything in the clauses that prevent it or explicitly allow for disclosure. I think the bigger issue is whether or not a company wants to do that, right?
And the reason I mentioned that, of course, in Sarbanes-Oxley, we moved kind of slightly in that direction, giving gatekeepers, in that case, gatekeepers, the obligation sometimes, and sometimes opening the door either to mandatory or to potential up the chain or out of the chain disclosure when they meet this. And that may be as effective a means of using private due diligence in this context, which then produces enforcement in the face of, you'd have to define, they have to be very serious, but certainly anything having to do with national securities or fundamental human rights prescribed activities may be something. But anyway, I just tossed that out there for you.
It's also, but also, like, one first thing I think of is you worry about defamation liability if you're disclosing something that might not be accurate. So you have to make sure that your disclosure is incredibly circumscribed to exactly the facts that you know them, right?
More due diligence for you.
Hmm.
Anyway, other questions. Sorry, this was
Sorry,
just...
guys.
Other questions? All right. Well, thank you very, very much. A just fabulous discussion, and of course, you've piqued my interest, and I didn't mean to take up all that time, but really appreciate this. And I will now turn it over to Claire. Claire, you got to unmute yourself.
Yeah, thank you. Let me just see if I can also share screen. Nope, hang on. Where are we? Come back. Yeah. Hold on. There we go. All right, can you see slides?
Yes. Yes, we
Good.
can.
Okay, thanks. Yes, and thanks, of course, to all contributing authors and participants today. To wrap off the proceedings, and we've had a very, very rich but also long discussion, so I won't aim to speak for too long now. I will give you in outline a summary of the paper, which will become a chapter that I'm writing together with Jonas Christofferson with reference primarily, but not exclusively, to the European Union Corporate Sustainability Due Diligence Directive proposal, chapter on corporate due diligence legislation, decoupling human rights from human rights law. So as the title suggests, what we're aiming to do in this chapter is to reflect on and analyze how the legalization of human rights due diligence appears from point of view of international human rights law. We'll also, in that context, give something of an emphasis to European regional human rights law, but of course the analysis, is of broader application. So what is due diligence? Of course, that should be number one, is the first question. I don't have to labor that point, I think, with this audience. But just in summary, good to recap on due diligence as a process that wasn't known in the same way to human rights law prior to UN guiding principles. We do have notions which will be addressed by other contributors to our edited volume who haven't been able to present their chapters today. We will have chapters which will relate the notion of due diligence as it appears in public international law and its historical origins in that context. So it's not that due diligence is completely unknown as a terminology or as a related concept in human rights law, but certainly the idea of corporate due diligence, corporate human rights due diligence, we take to originate with the guiding principles. And in that context, it refers to a process or a cluster of processes of a cyclical character which aim to, as has been said already during the course of today's workshop by other presenters, identify and manage risks of human rights abuse or violation linked to corporate activities, encompassing a multi-stage process of identifying, assessing risks of impacts on human rights via businesses' own activities, as well as their supply chain and other business relationships upstream and downstream. That entails, in turn, responsibilities to cease, prevent, or mitigate, track the effectiveness of measures taken to manage, address, and remediate human rights abuses or violations. And as Anil and Rachel's chapter discusses, also to disclose and communicate the information relating to the due diligence process and its outcomes. Importantly, in UN guiding principles, the responsibility to undertake due diligence, to implement due diligence, by way of operationalizing corporate responsibility to respect applies to all enterprises, albeit the scale and complexity can vary. And I'm just recapping these very basic points about due diligence as conceived in the guiding principles, because it is relevant later on as we consider how due diligence morphs from this UNGP's conception during the process of its legalization through corporate due diligence statutes. Equally, in the guiding principles, worldview, due diligence should entail that companies avoid causing or contributing to adverse impacts through their own activities, but as I've said, also human rights abuse and impacts that they might be linked to through business relationships, and the prioritization of different abuses to which companies may be linked is foreseen and tolerated in the guiding principles. So this is carried forward, this notion, into many of the soft law standards that have been the sequelae of the guiding principles in the form of the OECD guidelines for multinational enterprises. It's 2011, and of course its edition and the most recent update this year, as well as numerous other soft law, industry, and individual company standards. When we turn to corporate due diligence statutes, we do see specific responsibilities to undertake due diligence with a declination in the different statutes of due diligence, steps that to a greater or lesser extent map to those that are articulated by the guiding principles. As in the French loi de vigilance, we see possibilities for victims to advance claims relating to harms that allegedly are associated with due diligence failures of different kinds by companies, as well as other sorts of penalties. In the German Act, we see even more specific description of the due diligence process required of companies, encompassing the identification of risks, not just in relation to human rights, but also environmental destruction, a specific duty to devise and institutionalize a risk management system and grievance mechanisms to undertake corporate reporting, and the different kinds of gain penalties associated with failures in relation to these elements discussed by Birgit Spieshofer this morning, but not in this case, although it's an area subject to some discussion, as Birgit and also Carola touched on, not in the German case an explicit extension of civil liability linked to due diligence failures. So turning then to the EU directive or draft directive, here these slides relate to the original Commission proposal. It's a moving target as of today. Exactly what form, indeed, if any, the due diligence directive will take as a result of negotiations between Council, Parliament and the Commission, which are ongoing. But what we see in common with the French and German laws is, by contrast with the guiding principles, extension of a responsibility to business enterprises of all characteristics. We see a restriction of the personal scope of the due diligence responsibility to companies of substantial size. We see a sector-specific or sector basis also for personal scope, defined with reference to so-called high-impact sectors. We could have a separate discussion about the legitimacy of the carve-out in that respect. In some respects, we also see a restriction of the scope of the due diligence responsibility, which still encompasses the company's own operations and harms to human rights and the environment ensuing from business's own activities and subsidiaries. But beyond this, in terms of value chain relationships, there's somewhat of a restriction by reference to the requirement that the business covered by the legislation and the business which might be the immediate perpetrator of the harm in question must be linked by a so-called established business relationship. There is a lengthy description in the directive about the measures and steps that companies must take in order to be determined to comply with their responsibilities, which includes beyond identifying risks and taking steps towards the prevention or mitigation of potential impacts, actually bringing to an end identified impacts, which I think arguably does move towards, as Birgit Spieshofer said this morning, more than a duty of best efforts or a process-focused duty to a duty to secure a particular outcome, i.e. the prevention, the absence of human rights abuses or violations linked to the business activities. So we see that there are some subtle yet significant transformations of the due diligence responsibility as expressed in guiding principles when that is articulated through the medium of specific statutory enactments. The national legislation we looked at, the due diligence directive, which of course would in turn require to be given effect through national law at the level of the EU member states. What are the implications of this for human rights law? And as I think indirectly flagged this morning in one of my questions, I think it was to Carola, regarding human rights. Human rights is a term which features in all of these mandatory due diligence statutes that we've been considering. But in many ways, it's treated as a sort of monolithic, static entity, rather than, of course, a complex text, a complex set of interlinked legal texts and rights which have got a defined, if dynamic, meaning in different jurisdictions, which poses, I think, a set of challenges for due diligence legislation that haven't actually yet been fully recognized by legislators or indeed in scholarly discourse. So let's unpack that a little bit by asking the question, are human rights, in the sense that that term appears in due diligence statutes, are they, really the same as human rights in human rights law? And, to cut a much longer story short, and this will be addressed in greater detail, of course, in the chapter, but human rights law as a field within international law more broadly has got various characteristics. Human rights have got a specific content, which is defined in international human rights treaties, in the UN system, regional systems, also in national constitutions, which have, in some respects, common reference and analytical structure to human rights as they're found in international treaties, but in some ways are divergent from those. Also, of course, elements of human rights in common law systems may be found in common law systems. There are the key principles of international human rights law, which include, and human rights which include elements like universality, interdependence, indivisibility, as those have been articulated within the UN system, within the work of individual treaty bodies, and within the jurisprudence of regional courts. Crucially, it's also true that human rights are expressed at high levels of abstraction in international treaties. What they entail, the specific protection they afford to individuals, doesn't really become clear unless and until they're raised in a particular context. That is also something which is subject to dynamic or evolutive interpretation. We have, of course, in the European system, the idea of the living instrument. The convention is a living instrument capable of updating itself in interpretation, rather than being bound, strictly speaking, by precedent. We also have the contextualization of rights to specific groups of rights holders. So women's rights, children's rights, indigenous peoples also entail some specialization of general human rights context to those types of groups and scenarios. And very importantly, there's also recognition to differing extents across different regional systems and as between international and national systems, of course. But when it comes to international supervisory mechanisms, we have the notion of subsidiarity, that human rights mechanisms will not substitute their own evaluation of whether a qualified right for an interference with a qualified right was justified and proportionate in a given scenario for a decision taken by the primary decision makers, without affording some margin of discretion in the exercise of their prerogative, being closer to the facts of cases, and with respect to sovereignty. So there's a deference of some varying extent, but there is crucially in human rights law the exercise of some degree of deference or room for maneuver for national authorities, which is linked to their status as organs of democracy. So these are all underpinned, these principles and elements are all underpinned by specific jurisprudence within different human rights systems, specific case law of a quite complex character. But when we come to look at the directive, for example, in the EU context, we see an approach to defining human rights that doesn't, I would say, reflect this. So human rights itself, human rights are not as such defined in the draft, the Commission's draft proposal. When you look in the definitions section, what you find is only a definition of an adverse human rights impact, which means an adverse impact on protected persons resulting from a violation of one of the rights or prohibitions listed in the annex, which accompanied the Commission's proposal. And that definition of adverse human rights impact contains a number of interesting elements from a human rights law point of view. First being that it refers to an impact, defines an impact as having resulted from a violation. When a human rights lawyer thinks about the word violation, well, the first thing one contemplates is that that entails that there has been a state which has been a respondent to a claim, and that there's been an adjudication which has determined that all the different elements which would need to be in place to support that claim being vindicated were indeed found. So that's a really high threshold to meet in terms of preconditions for the identification of an adverse human rights impact, which doesn't really correlate with the notion of an impact as we would understand that in the guiding principles context, for instance. If we then turn to the annex, I've just included a short excerpt here on the slide, we see a list of violations of rights and prohibitions in human rights agreements, which is quite a peculiar approach and formulation in that, firstly, specific rights are extracted from specific instruments by reference to interdependence and indivisibility of human rights. That in itself is problematic, that the idea that you can cherry pick or make a selection amongst rights because the fabric of rights is so interwoven. So specific rights have been taken from specific instruments, which is a sort of rude, it seemed from a human rights point of view, sort of rude interference with the integrity of individual human rights instruments. But equally, in the Commission's formulation, instruments which are purely declaratory, such as the Universal Declaration of Human Rights, and therefore not capable of supporting a violation, are nonetheless advanced in this context as having that status of being legally binding instruments which can be violated in a public international law sense by a state party, which is just, it's not accurate. So there are a number of anomalies and disturbances that from a legal standpoint, human rights law standpoint, you would immediately observe in the way that this machinery has been set up. And of course, this is really important because also for the liability provisions in the proposed directive, because they rest on the foundation also of the notion of adverse human rights impacts linked, of course, to due diligence failure. So if there's a problem in the calculus here about how to identify human rights impacts, then it also will undermine the civil liability mechanism attached. yes, and these are points that made in this earlier made in this blog, which I co-authored with Jacques Hartman, on this topic of the annex and the way in which human rights, the scope of human rights is subject matter is characterized in the draft directive. So whether we can say, you know, human rights has retained a sort of meaningful legal definition or accurate legal definition as the term has been inserted into due diligence legislation seems quite questionable from a human rights law standpoint. And yes, I think I've already, yeah, the other, I think, other characteristic which this approach to defining impacts and violations and linking liability to abuses and violations so defined. The other problem with that is that it furthermore assumes a certainty to what constitutes a human rights violation that can't really be provided in many cases, or which doesn't exist in many cases. And just an example of that, we can point to this Holship case in the European Court of Human Rights, where actually the European Court of Human Rights, on essentially the same facts, reached a different determination on the point of whether Article 11 of the European Convention relating to collective labor rights had been violated or not, than had been determined by the Court of Justice of the European Union. So you have the two highest courts, one of the European Union and one of the Council of Europe, Europe's Human Rights Order, reaching different decisions on the basis of a slightly different legal analysis, but on the same issue. So that, I would say, provides a useful illustration of both the complexity, the contested nature of human rights, and how in that particular case also how qualified rights that can be balanced with reference to other considerations, how those mechanics of human rights law will be applied in different situations by different courts. So the idea that you can, if we go back, say that for companies, a violation is a sort of concrete, knowable in advance certainty, becomes much more difficult to sustain. And that creates problems around a duty of care and causation and harm when we come to look at civil liability. In the EU proposal, member states are required to ensure that companies will be liable for damages if they fail to comply with the obligations laid down in Articles 7 and 8. And as a result of this failure, an adverse impact that should have been identified, etc., occurred and led to damage. So reading in the full character of human rights law renders these sort of binary, the assumption that there is the determination of whether there is a human rights violation or not as a simple binary exercise, renders that assumption, I think, if not invalid, challenging. We think in our work, Jonas Christofferson and I, that approaching the articulation of due diligence laws, particularly with the goal in objective of establishing liability, civil liability linked to due diligence failures, in actual fact, is a driver for diminishing the ambition and the scope of the corporate responsibility to respect in the guiding principles. Because when it is, when the enterprise is to establish civil liability, of course, it becomes important to reduce in order to secure legal certainty, or with the notion of that legal certainty can be secured, it becomes necessary to limit the personal scope, which we've seen, of course, in the directive. Instead of all enterprises, it's restricted to the largest enterprises. It becomes necessary also to reduce the scope of potential liability in the supply chain. Therefore, instead of an open-ended responsibility to respect and due diligence that encompasses all business relationships, upstream and downstream, we have a much more circumscribed duty of due diligence, which refers to established business relationships, which may be an important, provide important scope for companies actually to subvert the intention of the statute by contracting around and out of established business relationships. Equally, it leads perhaps to the then exclusion, because it's essentially a sort of supply chain model of certain sectors, like the financial sector, as has been a controversial point in the context of the European Commission's proposal and the subsequent debate, exclusion of sectors like financial services, where, arguably from a human rights standpoint, much of the power in the economy globally is concentrated, and then, of course, which should be one of the sectors which certainly would be within scope of statutory due diligence obligations. So it seems to us that it's the tail wagging the dog. In a way, the goal of securing civil liability for due diligence failures that's driving sort of dialing down of the scope of the due diligence requirement in a number of other respects, in a way that retreats from the higher level, higher watermark set by the guiding principles. And at the same time, I think this is partly borne out by the analysis we heard from Lucas and Carola earlier on, Birgit Spieshofer as well. The prize of extending civil liability for due diligence failures to companies might anyway be vanishing, in the sense that there may be issues with legal certainty, there may be issues with reading down judicially in order to secure consistency with other legal principles and the integrity of tort law, the integrity of other aspects of civil and public law. Might be reading down of statutes in any case to avoid negative consequences in terms of legal uncertainty, lack of legal certainty. So these things have to be borne in mind, at the same time as there seems to be a sort of detachment between the fabric of human rights law and human rights as a transplant, a legal transplant from into the due diligence statutory frameworks, that should give us at least pause for reflection, and perhaps also some concern, given the value that you might attach to having human rights law, which is capable of giving legal effect to claims from individuals. If we don't want to either undermine the integrity of human rights law, perhaps we need to be cautious in transplanting human rights into this civil domain. So I think I'll leave it there.
Well, thank you very much. That was just a brilliant exposition. Questions? Questions for Claire? I've got one. And I'll make it brief because we are running out of time and I do want to close, but I can't let the opportunity pass. All of this makes sense in a world in which we're moving towards a uniform consensus-based system. But what happens when all of the trajectories that you describe, and they're all absolutely necessary, will lead to multipolarity in regulatory structures among people who absolutely positively agree with all of the principles and all of the regulatory trajectories, but that who come out with very, very different, sometimes very, very, very different normative either starting endpoints or objectives.
Okay, can you, I don't 100% understand the question, Larry. Multipolarity, there will be, are you saying that we're creating a number of additional sites where human rights are interpreted and given effect, and there may be, interference, contestation, between these different jurisdictions? Is that the
right? And but ironically, I mean, right now everything is off the table. But assume that this is kind of the ironic position that everyone buys into the vision that you've just created, which is actually an incredibly important and substantively rich one. But they all then use it to further what may be incompatible baseline normative either perspectives on the nature and purpose of social organizations, the nature and purpose of social organizations within a complex environment, or the nature and purpose as they interpreted of an ordering of human rights norms that then produce an inconsistency that cannot be fudged.
Yeah, well, I think you've answered your own question there in a way. If they're producing, if we have multiple, multiple jurisdictions where human rights are being interpreted, in parallel, in contradictory ways that cannot be fudged, that could be seen as a problem for human rights. This is, it's a very profound challenge. I think on the one hand, of course, human rights are nothing if they don't reach into the small spaces, Eleanor Roosevelt, and unless they are operationalized, unless they're grappled with and internalized, assimilated by organizations and institutions, then, and if they exist only in Strasbourg or, in the very infrequent decisions of other, some other regional tribunals, then, what's the point? On the other hand, if they are being spoken about in different voices, but with reference to the same texts and standards, and the resulting cacophony is unintelligible, then we also have a problem. Yeah.
All right, Sara, last question, last word, and then we will close up.
Sorry, I just wanted to say that if one looks at things from having taught private international law, it's not unusual, or the basic assumption is that you can have a foreign law applied by the forum court, and they're not going to apply it or interpret it in the same way as it would be applied or interpreted in the host state. So in essence, the cacophony and dissonance is just the way it is. And I guess that's my, I'm not sure that there's any way around that. So it's maybe thinking of it more as a process, as contributing to a process of agreement on what norms could or should be. That's not helpful from Birgit's perspective in terms of we need to advise the companies on what they're supposed to do. but maybe it's just how it is. And anyway, that was a very useful presentation. So thank you. I really appreciate that.
Okay, and I know it's getting close to 6, and my magic carriage is going to turn into a pumpkin, and I'm going to have to run home. But I want to take just a second to thank all of the conference participants and to thank all of the attendees for a set of brilliant presentations and brilliant questions. Thank you so much for attending and for participating. A very long program. I look forward to to engaging further with all of your chapters and to put together a book that I hope will be very, very useful, not just for us, but for the communities in which we're working. And I leave the last word to Claire.
Yes, well, likewise, just briefly to respond to Sarah's point. Yeah, I think this is a really interesting question, whether, you know, the same rules apply, the same principles apply when it comes to, you know, applying human rights law of other jurisdictions in a private law setting, in a, you know, in a second jurisdiction, whether there's a qualitative difference there or not. I think there could be. You know, I think if we were considering, you know, as has happened, you know, as to some extent has happened in the litigation that we've seen, you know, courts in the global north applying constitutional rights jurisprudence of countries in the global south, is that a legitimate, you know, to what extent is that a legit, or does that raise issues of legitimacy, or, you know, or indeed other kinds of issues? So I think this is something that we'll all have to, you know, sort of deepen our reflections on and extend our analysis of. But besides that, yeah, and it's a really important point, so thanks for raising it. I would just also like to extend gratitude to everybody who has contributed today, both amongst panelists and other participants, and to authors, of course, all of you who've been with us, but also those who haven't been able to make it. We hope you will have a chance to catch up with a recording of the workshop at a later date. But thank you so much for your support for this project.
Folks, good night.